Here we go. Today we're doing appointments. So appointments deal with all kinds of areas of eState. So there are the estate trustee appointments, guardian appointments, powers of attorney appointments, trustee, so gift trustee appointments, special trustees for different trusts, all of those things. And they all work the same way. So I'm going to just show everybody some basic things and then answer any questions on appointments. So for any kind of appointment, I'm clicking on the appointment tab here. This is under wills. So I'm clicking under the appointment tab, and that's where you'll find estate trustees and guardians. So we'll focus, because they're all pretty much the same. I'll just focus on estate trustees. It's the most common. So what I'll do is I'll click the add button. Now, trustees and estate trustees, any appointment, they're broken down into primary appointees and then alternate appointees. So the first thing to do is to think about who's going to be, assuming people are alive or whatever, who's going to be the primary appointee or appointees, depending on how many you're going to add. So I'm going to appoint Abraham. I'm going to pick him. You have to pick each appointee individually. So you can't multi-click a bunch of people because their condition might be different, and I'll explain what that is. So there we go. We're appointing Abraham. Now, if he's a primary appointee, that is, he's not acting under some certain condition, like if so-and-so can't act or something like that, then he's not going to have any condition to his appointment. And we're just going to go add. So you can see that Abraham is now the sole primary appointee. I'm going to appoint another primary appointee. Maybe I want two people to act as primary. So let's pick Billy. And again, Billy's going to act regardless of anything else. So we don't need a condition down here, okay? And I'll show you some conditions. So once you appoint more than one person to be acting, there comes decision-making options. Now, with estate trustees, there's really there's no such thing as joint and several appointments for estate trustees. There are for attorneys for property and personal care, but not for estate trustees or trustees generally. And so we don't offer that option. Basically unanimous, or if you want to come up with some other way of doing it, go ahead. It's a free form condition or decision-making. So right now we have two people, A and B are acting, or Abraham and Billy are acting. Now we want to appoint an alternate, okay? So what we'll do there is, again, add, and let's say we want Glenda to act. Now, we don't want Glenda as a primary. We only want Glenda to act, for example, if both Abraham and Billy can't act, okay? So we're going to add a condition, which is if specified, cannot act. Okay, that's the condition. And now we're going to specify which people. So she's going to be a replacement for Abraham, but also for Billy. Okay, so she's going to replace up to two people here. Now, we have a condition, a second condition, which is she going to act only if all of Billy and Abraham can't act, or if any one of them can't act? So that's what those two replacement conditions. This is the one if you want Abraham and Billy to act, or the survivor, and then if they're both gone, I want Glenda to act. This one is I want Abraham and Billy to act, but if either of them can't act, Glenda steps into their shoes so that there's two potentially. So that's the difference there. So we'll go with the more classic one, and you can see it tells you exactly. It's if Abraham and Billy can't act. Yes, that is the condition that Glenda would act under. And that's why you can't add more than one person, because we could have all different kinds of replacement options here. We could have Glenda if Abraham and Billy can't act, and then if Glenda can't act, then it's Heather. So what we would do is, now Heather's going to only act if Glenda cannot act. So we'll go like this, done. If Glenda cannot act, yes, and that's the condition. So when you're describing it to the clients, you can show them, or as I do, I show it to them live. We've got Abraham and Billy first, then Glenda if Abraham and Billy can't act, and if Glenda can't act, Heather is going to act. And so that's that's how you create these conditions and the appointments. And you can do complicated ones, right? You could say, I want Glenda to act only if Billy can't act. She's a replacement only for Billy, et cetera, et cetera. So you can build that out using those options however you like. As I indicated, there's no such thing as joint and several. However, if eState sees that there's more than two that can ever act at one time, then what's going to happen is it's going to build in an option for majority rule. Okay. Why now does majority rule show up? Well, it sees that there's some situation where there could be more than two acting. And if there's more than two acting, then how do you want them to act? Do you want them to act unanimously or by majority rule? And so let's say we wanted to go by majority rule. So now we have two options under majority rule. We can have the simple majority, which means any 2 out of 3, for example, because there's 3. 2 out of 3 would be a simple majority. But we also have the condition where we have a majority, but at least one or more people have to be part of the majority in order to carry the day. And you see that, quite frankly, with trust companies, where they say, fine, we'll do a majority rule, but we always have to be part of the majority. We don't want to ever be outvoted. So if you wanted to do that, you could put that person in as the member of who you would want to be part of the majority. So that's how you would do that. And then there's dispute resolution. You can add a dispute resolution clause in there that if there's a dispute, this is how we want it resolved. We want it by mediation, and you can put in whatever description you want. And then there's compensation. Now, compensation, I'm just going to click on that. We have a few different options here for compensation. We have none. So none of the estate trustees get paid. We've got other. Okay, let's skip other for a second. We have the default, which is what Ontario law says, which is it's going to be up to the consent of the beneficiaries or a court if they can't get the consent of all the beneficiaries. So that's court's discretion. Then we have fixed by agreement. So if you're, if your estate trustee has an agreement with the testator as to what they're going to get paid, then you can do it that way. Or the last one is fixed in the document. So this is one where you want to state exactly the method of compensation that an estate trustee or any appointee would get paid. So we have a few options here. We have a lump sum, we have an hourly rate, and we have a percentage. And if it's a percentage, what's it a percentage of? Typically, we do it as a percentage of receipts. And then you can exclude certain people from, being compensated in that way as well. So if I want my estate trustees to be compensated, all my estate trustees other than Glenda to be paid by a percentage, then we can do that. And eState will draft that appropriately. So, so that's sort of how you use the appointees and the additional provisions for compensation, dispute resolution, decision-making for appointees. Similarly, you would see in powers of attorney, you do it the same way. We want Marge to act. And then let's say we want a trust company. And what we actually came across a few times with people is they didn't realize that we support trust company appointments. They put in a trust company as a person. Well, we support the trust company. So if your clients want to appoint a trust company, instead of picking from the people list, click on trust corporations and then pick the appropriate trust company that your client wants to appoint. So if it's Royal Trust, do that. We'll appoint Royal Trust, but only if Marge can't act, right? So we go to condition, we pick Marge, and now Royal Trust would only act if Marjorie can't act. There we go. And one of the great things is that eState will automatically put in all of Royal Trust's clauses in the power of attorney in this case, or in the will that they require. you don't have to worry about the fact that it might not comply with the provisions that they want, etc. The other thing that you'll see, and I'm just going to open it up on the screen here, for property, is that you'll see it appoints Marge first and then Royal Trust. Don't worry about all these test things. This is our demo account, so we show people how they can put in their own provisions. But what eState is going to do is it's going to make sure that the clauses that Royal Trust wants are in here. And so it's going to reference a fee agreement automatically, because it knows that any trust company is going to want a fee agreement. So that's why it does that automatically. You don't have to worry about it. So that's kind of how eState works for appointing trust companies. And as I said, we have most of the big, we have all the big trust companies. And we're always happy to consider putting in other trust companies, smaller ones, depending on the need and demand for that, because they do take a fair bit of time to add into our system, because they all have to. We have to have different clauses for each different provision. So that's how you appoint estate trustees. Powers of attorney, guardians. Same thing, you just appoint whoever you would want to be the guardian, and then you can always add, in this case, Greer's the primary, but you can add alternates as well. And the last thing that I want to show you is how you could appoint different trustees for a trust gift. So let's do this. So let's say, for example, we're creating a trust, whether it's an asset trust or a trust of cash or residue or anything. One of the options is the selection of the trustees. And in many cases, I mean, typically the trustees for a trust are the same as the executors. So by default, that's checked off. But in some cases, you might say, listen, I want X to be the executor and I want Y to be the trustee for these trusts that I'm setting up. And so in that case, you would just unclick the trustees. Up comes the list of what your current trustees are, and you can clear it and add your different ones. So in this case, I'm going to clear all those, and I want Billy by himself to be the trustee of the financial trust. And eState will draft that. I'll just go to a short will, let's say, and show you how eState does that. So the appointments of trustees are done the same way as the estate trustees or any trustees. And I'll just show you kind of where this is a complicated will, I think. Okay, here's what we did. So remember, we appointed a separate, a special trustee, in essence, for a trust. Here, it's Billy. So Billy is going to be the trustee of the child's fund in this case. And so the appointments are done the same way. So let me just show you, maybe there's something to show you here in compensation. Might have to use yeah. So remember, we excluded Glenda from getting compensated. So that's what eState did. It said, my trustees except shall be compensated as follows. So that's what we do. And the guardians are all, so that we had Greer, right, appointed as the guardian. So it does that clause. And of course, it does the appointment of the executors. So my father and Billy and Greer, and should both, we had the replacement of Glenda for both Abraham and Billy. And you can do all kinds, like, obviously this is a crazy one that probably you wouldn't see very often, but it can do all of those things. So let's just see what's in the chat. So a question that was asked was, how do you deal with the compensation if the lawyer who's drafting is also the estate trustee? Yeah, so it's, it does raise concerns, about independent advice. If the estate trustee who's the lawyer is getting compensated at either the usual rate, which is by default the consent of the beneficiaries, or by court approval based on the usual tariffs and all of those, or usual guidelines and all of those things, then I think you have less of a problem. If all of a sudden you're saying, I'm going to get my hourly rate for administering the estate, and your hourly rate would work out to be more than normal compensation, then I think you have some issues. You might have some issues down the road. I guess the most extreme thing you could do is you could send that person out for independent legal advice, although I don't think that's typical. The Law Society has said we can't draft a will where we're a beneficiary, but it doesn't say anything about we're allowed to draft wills where we're appointed as the executor. But it's important that whatever you're going to do, you have good documentation that you provided them with advice that was objective, and didn't seem to benefit you personally. If that's explaining to them exactly how any third party executor might be compensated, and what options there are, I would think that I would take the client through all the different options before. So that might be your typical family, friends, all of those things, trust companies, and then I'd say, and then there's I would be willing to do it as well. And here's how we operate. So that would be my 2 cents on that situation. Any questions about appointments? No. Sometimes I'm going to give you an example of let's say I'm doing a grandchildren's trust, okay? And I'm giving each grandchild a 100 grand, okay, in a trust. I want the parent of the grandchild to be the trustee for each of the respective grandchildren. So I have 3 kids, and each of them has children, and for each of those trusts, I want the parent to be the trustee for their own kids' trusts. So what I'm going to do is I'm going to unclick same as executors, because I don't want the same executors. I'm going to clear those. And then I'm going to click on other. So when there's an option for this kind of appointment, you'll see there's now people, which is a list of all the people. If there's somebody on that you haven't put in, so the client says, listen, I want my accountant. Okay, well, your accountant might not be in your data already. You don't have to go anywhere. You can just click on add new person and then put their name in, and you might specify whatever you might specify, and then you can pick in the relationship. So let's say I'm the accountant. Now I can pick that person as the appointee. Okay, so you don't have to go back to the people tab and add them in. You can add them in right there. So that's how you would add a person that doesn't already exist in your list of people. But I'm going to remove myself here. And instead, I'm going to talk about the other category. So this is a situation where we have a bunch of beneficiaries. eState sees that, and we can appoint a kind of a class, if it were, or a status of a person, rather than an actual named person to take this on. So I might say, listen, I first want the beneficiary's parent to be the trustee. Okay. Now, if that parent who's related to me, now that's where, if you're talking about grandchildren, you're talking about your child. Okay. Your child, because they're related to you. Now, I might say, well, and if they can't act, then I want the grandchild's other parent who's not related to me. Okay. But I only want that if the beneficiary's parent can't act. Okay. So that's how you can appoint sort of like a type of person rather than a name. And what will happen is, I'll just show you what will happen. eState will say, okay, for each of the grandchildren's trusts, the trustee is the parent. I'll just go to that spot. So here, my grandchild's fund trustee means the parent of the beneficiary who is my child. And if that parent who is my child is unable or unwilling, the parent of the beneficiary who is not my child shall act. And so that's how it would draft it. So that way, and that's not unusual when you're doing grandchildren's trust, where you don't want your other kids being the trustee of one kid's children, as it were. So we have some extra features in there about, for those kinds of situations. So that's really all I had to talk about. Anybody, please feel free to unmute and fire away with any questions about appointments first. And then if there are none of those, just generally anything about eState that you have questions on. So I was getting, James, I don't know if that was you, but I was getting a bunch of feedback and no discussion. So I didn't know if you wanted to talk or not.
Sorry, Jordy. I just, it's kind of an extension of the appointments. It's obviously dealing with compensation. And obviously, there are different combinations of that. But in my practical experience, you find is the place to which conflicts arise. So the go-to is basically the court decision or agreements of the beneficiaries et al. What is your guidance related to that? I mean, I know it's not specifically going into the eState for what you're doing today,
No,
but it's just something.
Sure. I mean, it's the default because that's our law. Our law is default.
I understand that. I understand that.
And so, the good thing, I don't mind the default because there are built-in safeguards for ensuring that whatever compensation they claim is fair and reasonable based on what a court would say if the beneficiaries don't agree and if their lawyers don't advise them to agree. The thing about compensation is you might not, it might look like a really simple estate when you're setting it up and their assets, but when they die, it's much more complicated and you've either undercompensated them or vice versa, you've overcompensated them. So my general rule is to go with the default unless the estate is so large that, listen, they're going to get overcompensated if we use a percentage approach. And the client's more comfortable with an hourly rate or something like that. But I generally default to the Trustee Act provision.